Good afternoon, ladies and gentlemen. Thank you for the opportunity to come and have a chat with you. I am unfortunately going to disappoint everybody that was so excited about my topic, that was looking forward to a speech regarding abstract. There was a mislabeling in the program. My actual topic is going to be the legal requirements of digital search and seizure in South Africa. The aspect of my search is, or of my address to you is, the requirements in terms of law enforcement when they're conducting digital search and seizures. It has always been a passion of mine, the aspects of are we able to actually successfully prosecute and investigate these type of cases. So the whole focus of my investigation and my talk today is not to be disrespectful to law enforcement, but it's actually my passion to make sure that we improve the level at what we are doing these type of investigations so that no criminal when caught actually gets away. So please see it in that light. I know that there might be some law enforcement officers in the room, and that is my aim to actually add into it. I've been speaking about this topic for a number of years. I actually started off in law enforcement. In my heart, I'm still law enforcement. I don't like working for the defense, but in my heart, I still fight for the guys in blue. So one of the problems that we've got is, and the focus area is, are we satisfied with the solving rate of our cases? If we look at common law offences, the typical investigations, fraud, corruption, murder, those type of things, you'll agree with me that the success rates are quite low. Now if we combine that with digital forensics and we combine it with cyber crime, it actually impacts on it. We're seeing that the more technical the case, the more difficult it is to investigate, the more difficult it is to actually get the court to understand the type of evidence that we're presenting to them. Now I'm going to give you a quick overview so that you just understand some of the concerns and some of the challenges that we've got from a digital forensic point of view. So one of the biggest things is we must be able to prove our evidence in court. If I come and I investigate your computer and I find a letter on it to say this is how I'm going to throw a birthday party for the professor, I can very easily log on to that computer and change it to say this is how I'm going to kill the professor. So, excuse me. You see, you weren't focusing. That cake they brought you might be poisoned. So the fact of the matter is we're sitting with a situation where law enforcement goes, they seize computers, they seize cell phones, and they transfer those devices to Pretoria, Cape Town, etc., where it is then analysed. Months, weeks or months later, a suspect is then confronted with the evidence that is found against him, and that evidence is presented in court. Now, if the judge already doesn't understand what cybercrime is, what is a bot attack, and what is a firewall, and all of that, he is inclined to actually throw that evidence away if there's sufficient challenges against it, if he doesn't understand it. And we want to actually prevent that. So we've got a couple of things. International principle says that the activity of law enforcement shouldn't change the evidence. Okay, so if I access a file, if you open a file on a computer, it says it's opened. If we've got a practical situation where law enforcement sees a person's computer in January, and it shows that files were modified or created or accessed in April that year, 3 months after law enforcement actually seized it, the courts are sitting with a situation of what changes were made. How can you guarantee for me that you didn't plant the evidence, that you didn't influence the evidence? So we want to conduct the investigation in such a way that we actually don't change it. Then also we've got the Electronic Transaction Communication Act that says the integrity of data is assessed by looking at whether that data has remained complete and unaltered. If I can show that there's a file that was modified after the police seized it, it's going to cause big problems for me. So what we do, and just in a nutshell, we use specialized tools, write blockers, for example. We remove the suspect's drive from their computer, we connect it to a write blocker, and we make a forensic sound copy of it. That forensic sound copy, we use specific software for it. It calculates an algorithm that runs over, and it basically calculates an MD5 hash or a SHA hash value, it's the electronic fingerprint of that piece of evidence. So this is how, when we seize a computer on the scene, we can show years later that no modification was made by the police force. So typically, you've got your general policemen, your detectives, all over the country, seizing computers, cell phones, sending that to a central repository, labs situated throughout South Africa, and the police then follow similar processes like this, and they make forensic copies. The fact of the matter is we can't be on every scene. A policeman or a digital forensic expert cannot be on every scene. There's just too many of them. So that's how the evidence gets sent to them. Now, what we've got is on the other side, we're looking at the requirements of search and seizures. So with our history in South Africa, where we're sitting with apartheid and how search and seizures were abused, our courts are looking very, very specific at what they are allowing. So typically, if you've got a situation that where the policeman doesn't describe the items he's going to seize, if he describes it too vaguely, they're going to say it's an overbroad search and seizure. So for example, if I come to your premises and I've got a search warrant to search for water, bottles of water, for example, which is simple, I cannot come and seize your computers because I got permission from the court to actually only search for water. So you understand the concept? Very, very easy for us to then apply that in what I'm going to discuss with you further. So now what we've got is we've got this situation where law enforcement and forensic investigators across the board actually seizes whole computers. So if I come to you and I say, ma'am, your computer, how much of that is private? If I say that I want to come and seize everything regarding your work, how much private stuff is also on it? Your Gmail account is on it, your banking is on it, your family photos on it, maybe some naked photos on it. Not of you? Just an example, somebody else. So what happened in this case, quite an old case, but it's still relevant. The judge basically, they convinced him to say, listen, judge, this has become the standard way of doing digital search and seizures across the board. Because the problem that we've got is, I cannot come to this lady and say, I only want to seize all your Absa Bank related communication. It'll take me days to go through this computer. I need to do data recovery because she's a suspect. She might be deleting the information, hiding it. So we can't accept or expect law enforcement to only for that couple of hours on the scene segregate what is relevant and what's not relevant and seize it. So law enforcement takes the whole computer. Okay? The judge in this situation said that as to the allegations by the respondent that this has become the standard way of searching for electronically stolen information in South Africa and elsewhere in the world, if this is so, in my view, it's not sanctioned in terms of Section 20 and 21 of the Criminal Procedure Act, where you're seizing the whole computer. It's the same as I'm seizing a whole filing cabinet. If I'm saying I'm looking for invoices regarding transaction A, B, and C, typically when law enforcement goes to that scene, they're not allowed to take the whole cabinet. They're supposed to work through the documents and only seize what is relevant. But with computers, we are challenged. As one of the previous speakers also commented, we're sitting with outdated legislation. Legislation that was written, so to give you an idea, the Criminal Procedure Act was written in, what was it, 1977? 51? Which one is it now again? Can't even remember. But it is so outdated, there was no concept of computers at that stage, more or less. So we're sitting with a situation that if we look at physical search and seizures, a policeman needs to define the date range. I'm looking for invoices from this date to this date, or crimes from this date to this date. Physical premises is defined. It needs to define the item that they're going to seize, a bloody knife or a dacha or whatever. Privileged documents may not be seized. Privileged documents, communication between you and your lawyer. No overbroad seizure, only relevant items may be taken. Only one search of the scene, and thereafter the search warrant expires. So if I come to your premises, I searched your house, I can't leave the premises and come back the next day with the same search warrant. It's expired. Item is seized by taking the original away, and the suspect can have a copy of it. The searches are listed in the search warrant. The premises is searched in zones. So I go through every room. All items seized are listed on the receipt that I give back to the person. Extended or search after hours are only permitted on special requests. If suspect is present to oversee that the search is done in the right ambit and have an immediate legal recourse. If we compare that to what is happening with digital search and seizures, we cannot define the dates, because if I transfer my files from one computer to a new location, it gets new creation dates. Should the PC be specified as the premises, the computer, or is it a digital environment? Is it cyberspace that we're defining? Should the data on the device be described as the item? Am I seizing the data or am I seizing the item? Privileged data cannot be removed. Data is intermingled and cannot be segregated. 3 searches. So 1, I find the computer on the premises, then I still need to search through it, and then I need to apply my mind in terms of what does the content tell me. Does the seizure, so typically what the police do is we take our forensic or a clean hard drive, we utilize that hard drive to make a forensic copy to, and we keep that copy. Now, if I haven't seized the suspect's hard drive, did I really seize the data? I made a copy of it. It's like the same as a photocopy, for example. The digital forensic investigator is the searcher and not necessarily your detective on the scene. Data recovery, search cannot be limited, so if I'm doing data recovery, I can discover all the legally privileged information on it as well. When does the warrant expire? So if a detective sees the computer, so say for example a detective lists this computer, I'm looking for invoices on a computer. If they find that on the scene, the search warrant is executed, it's done. But now they send that computer to a central lab. The digital forensic expert is the guy that actually searches through it to find what is relevant. So is that still covered under the first search warrant, or do we need a second one for it? And who's the searcher then? What does the warrant expire? Searches are performed off-site with no supervision and can be repeated unlimited times. So I can search now, for example, if I've got your computer, I can go back to that scene over and over again. If I've got your computer for 4 months, I can search it 20 times. But with a normal search warrant, I've only got 1 bite at the apple. Non-relevant data is also retained. So for example, let's say I search through your house. I take all your documents and stuff. I've gone through it. Now I have to return everything that's not relevant. With your computer, it doesn't happen. The police keeps a copy of it until you go to court. So let's say, for example, somebody makes new allegations. Are they coming with a new search warrant, or do they just open up that copy and search through it? What constitutes a search? Exposure to human notice, or if I execute, for example, a search function, is that constitute that person has actually taken a cognizance of the content. To give you an idea what's happening in America, they had this case where the total bench of judges came back and they made a couple of requirements. If a policeman wants a search warrant where they are allowed to take away the whole computer, the state must waive the reliance on plain view doctrine. So for example, if I seize the computer to investigate it for corruption and I found proof that the person was dealing in drugs, that is in plain view. If you want to have the whole computer, then you must basically walk away from the fact that you can discover other types of crime. Segregation of relevant and non-relevant data must be either done by a specialist. If segregation is done by the state, it must be agreed on in the search and seizure warrant application that the computer personnel may not be disclosed to the investigator any other information which is not part of that first search. Search and seizure warrants applications must state the actual risk of the destruction of information. The search protocol of the state must be structured and only uncover information containing probable cause, and only that information may be examined. The state must destroy and return non-related data. Luckily later on they overturned their judgment and they made it guidelines. So this is how strict it is done internationally, that you need to adhere to these requirements. In South Africa currently, we're sitting with a situation where the digital forensic investigator never goes to the scene, or very seldom goes to the scene. It's actually a detective that seizes the computers on the scene. The digital expert does not see the warrant, so he doesn't know what's specified in the warrant. He gets instruction from the investigating officer or the detective in terms of what he should be looking for. So now we're sitting with a situation where that suspect never knows what they are really searching on the computer. Typically what happens, the detective will ask for all user-created data so that he can work through the information and determine what is relevant, what not. The investigating officer then reviews the information, and he basically prints evidence that he wants to use in court from that work product. And lastly, the interview, that was one of the high-ranking officers, actually said that it felt like he was going on a fishing expedition every time that he was conducting an investigation. So by basically studying international situations and what is acceptable, I've come up with a number of things, advice in terms of the procedures that should be taken. So number one, the presiding officer, the judge, must be informed that they will be seizing computers. Forensic investigation should include the mechanisms they will employ to protect constitutional rights of the suspect. For example, what are they going to search for? These mechanisms should include the suspect may be present, or review the process of how the police are searching through his computer. Now, it's not practical for having the suspect present, but it should be documented and reported on, for example, in the trial. What were they searching for? The segregation of relevant and non-relevant data should be a mandatory step. So what is relevant, what not, should be split. Independent filter teams must be used to do that segregation. Independent filter teams should be limited to search only for data defined in the search and seizure warrant. They cannot accept any other instructions that's not defined in the original search warrant. The analysis of data should be performed according to a strict investigation plan, and not just a fishing expedition where they're going through every single document and file on that computer. Only relevant information may be disclosed by the digital forensic investigator to the detective or the investigating officer. So by following that process, we will be actually protecting the rights of the suspect as well. General recommendations: the seizure of computers should be permitted. We cannot do it in any other way. We should be allowing an off-site search of those computers. The investigator should be allowed to seize computers only for a specific period. The other aspect is, if I take your cell phone away, to have it analyzed, what is the acceptable duration? It looks like you might be a good cell phone user. How long can I keep your cell phone? A day. Well, currently what we're seeing, it's between 14 days and up to 6-7 months. Okay, so, and that's your computer as well. So, you know, how are we limiting that? There are rules, there are legislation in countries like Australia, America, New Zealand, where they've got a specific period. The police must make a copy of it within 7 days and return your device. If they can't do it in 7 days, they have to apply for permission to keep it longer. Duplicate copies, the process that I described to you, must be seen as an original record, so that the police can actually conduct the investigations on it. And then, thank you, ma'am. And determining if data was searched, it should be addressed whether the content of that data was, and it was to what extent exposed to human observation. So one of the aspects is the criminals will come and say, listen, you conducted an overbroad search. So for example, if we can employ keyword searches where a person doesn't actually see the content, we can scan computers without breaching a person's privacy. So those are some of the suggestions that I've got in terms of how we should adopt our legislation, how we should adopt our standard operating procedures in conducting digital search and seizures. If you're interested in more information, I've got a couple of articles published that you can refer to. On time.
Yeah.
Thank you very much.